January 30th is not a date on a calendar anymore. It's a tripwire. And if you miss what quietly activates on that date, you can be fully legal, fully employed, fully tax-paying, and still get flagged like a compliance problem before you even realize a rule changed. Hours ago, the White House signed a sweeping immigration statute that rewires how status is monitored inside the United States, not for new applicants. For you, if you hold a green card, if you're on an H1B, if you're protected under DACA, the entire system just pivoted from passive oversight to active verification. And the danger isn't a dramatic mass cancellation. The danger is the bureaucratic kind, the kind that freezes your work authorization, delays your travel, or forces you to prove your life with receipts on a deadline you didn't know existed. You're watching Immigration News Desk, and today is not about panic. It's about the hard reality of how modern enforcement works when it's digitized. It doesn't kick down doors first. It builds a database, sets automated triggers, and waits for you to fail a check you never knew you were taking. Stay with me, because in a few minutes I'm going to walk you through the single most underestimated threat inside this law: retroactive compliance. People think, I got approved years ago, so I'm safe. That assumption is the devastating mistake. Later, I'll show you exactly why January 30 is structured as a trigger point, what gets easier for the government after that date, and what you can still do before the net tightens. Now, you need to understand why this feels different from almost everything you've lived through in immigration policy. In the last decade, major changes often came through executive orders, agency memos, policy manual edits, or temporary guidance, things that could be paused by litigation, softened by internal discretion, or reversed by the next administration. You've seen that movie. A headline drops, panic spikes, lawyers sue, and the government updates guidance. That is not what this is. What was signed is framed as full legislation, passed by Congress and locked into federal law. That matters because it changes the terrain. It moves the fight from agency interpretation into statutory obligation. It reduces flexibility, it hardens deadlines, and it gives agencies something they love: explicit authority to demand information at set intervals, not merely when something goes wrong. The statute, as described in the source text, is titled the Immigration Status Verification and Accountability Act of 2025. The branding is sanitized: verification, accountability. But the operational concept is blunt: continuous accountability through continuous data matching, a unified digital system that connects immigration records with employment data, travel history, and tax compliance into a single verification framework. If that sentence doesn't scare you, it's because you haven't seen how compliance regimes evolve. They start as efficiency, they become risk reduction, and then quietly, they become a regulatory dragnet. Because once the technology exists, the temptation to use it is irresistible. Here's the bigger historical context you were never taught in school. U.S. immigration enforcement used to be slow and human: paper files, local offices, case-by-case discretion. Then, over decades, especially after 9/11, the government built a surveillance and screening architecture in layers: entry-exit data, biometric databases, watch lists, automated cross-checks, employer verification programs, information sharing between agencies. Not one single big bang. 1,000 incremental upgrades, each one justified as modernization, each one expanding the state's ability to detect anomalies. This law is the logical endpoint of that evolution. It doesn't need to hunt for violations the old way. It can scan for inconsistencies at scale. And in compliance systems, an inconsistency is often treated as guilt until proven otherwise, even when the truth is mundane: a moved apartment, a delayed tax filing, a worksite change, a passport stamp error, a database mismatch. That's why the first wave matters before January 30th. Because the law doesn't have to deport you to hurt you. It can throttle your life through administrative review. And administrative review is where people bleed time, money, and stability. Now let's slow down and translate what was signed into plain English, because immigration law isn't just about what it says. It's about how it gets enforced. The law is described as having four functional pillars: one for permanent residence, one for employment-based visas like H1B, one for humanitarian protections like DACA, and one for enforcement timelines and penalties for non-compliance. The most important line in the source text is not the title, it's the structure. It creates checkpoints at specific intervals and under specific conditions. You are required to confirm that your status is still valid and that you're meeting ongoing requirements. If your information aligns, you move on. If anything doesn't align, missing information, outdated records, unexplained gaps, you get flagged for review. Not punishment first, review first. That sounds reasonable until you understand what review means in a digitized bureaucracy. It means holds. It means requests for evidence. It means processing queues. It means your employer gets nervous. It means you cancel travel. It means you lose opportunities because your status is pending verification. It means, in the worst cases, a suspension of work authorization while the machine sorts itself out, through no fault of your own. And this is where I need to open a critical loop. The most dangerous part of a verification regime is not the check itself. It's the deadline to respond. People lose status not because they're ineligible, but because they miss a notice, misunderstand a portal message, or assume silence means safety. In a few minutes, I'm going to tell you the specific kinds of small oversights that become catastrophic under this law, because the law is designed to treat neglect as risk. Now, the statute is also described as retroactive in application. That phrase is easy to gloss over, and it is exactly where people will get hurt. Retroactive doesn't necessarily mean we punish you for lawful behavior. It means the compliance expectations attached to you now, regardless of when you were approved. Your green card, your H1B, your DACA protection, those are not one-time trophies. Under this model, they are statuses you must continuously validate against multiple datasets. You are no longer simply approved, you are trackable, and the government is no longer waiting for something to go wrong before it checks. That's the shift, from reactive enforcement to proactive verification. The old honor-based assumption, we trust you unless you trigger suspicion, is being replaced by prove it at intervals or be flagged. If you want to understand why, it's not just politics, it's capacity. A government that can't verify everyone relies on triggers, arrests, border encounters, applications, tip lines. A government that can verify at scale creates periodic audits. That is what this law represents. The state leveraging data infrastructure to expand enforcement without expanding manpower. Let's talk about who is exposed, because the law doesn't hit everyone equally. Some people will glide through. Others will feel like the floor moved under them. The three groups facing the most immediate operational impact are green card holders, H1B workers, and DACA recipients. And the danger for all three groups is the same. You believe you're safe because you've never had a problem before. You renewed successfully. You traveled before. You stayed employed. You paid taxes. You stayed out of trouble. That belief is exactly where a bureaucratic trap becomes effective. Because verification systems don't care about your feelings. They care about alignment across databases. And databases don't understand nuance. Let's start with green card holders, because this is where the largest number of people will be blindsided. Permanent residence has always been framed like stability. Live here, obey the law, don't abandon residency, renew your card. For years, unless you triggered something, like a criminal case, a long absence, a suspicious re-entry, the government didn't routinely check in on your residency intent. The system relied on inertia. This law ends that. It places permanent residence into an ongoing status verification framework, described as periodic formal verification at set intervals, currently referenced as every 18 months. Think about what that means operationally. Every year and a half, the government sends you a notice, mail, portal, or both, and the clock starts. You must confirm your physical address, your employment or financial situation, your travel history, and your continued intent to maintain permanent residence in the United States. And before you tell yourself, that's simple, it's only 20 minutes online, understand what the system is really doing. It's not asking you for information because it doesn't have it. It's asking you for information to see whether your answers match the records it already has, or thinks it has. And if they don't match, you don't get a friendly error message. You get escalated into administrative review. That review is not deportation, but it is coercive. It is slow. It is stressful, and it can become a barrier to naturalization, to travel, to job mobility, to sponsorship of family, to your basic sense of security. Here's a real-world scenario, because this is how people get trapped while believing they're model residents. Imagine you're a permanent resident through employment. You have a home here. Your kids are in school here. You pay taxes here. You're settled. Then your company sends you abroad for 8 months on a temporary assignment. Under the old system, that might never surface unless you were questioned at re-entry, or you later applied for citizenship and had to document travel. Under a verification regime that cross-matches travel history, your 8-month absence becomes an automatic flag, not because it's illegal, but because long absences are correlated with abandonment cases historically. The system is designed to ask, where is your real life anchored? Now you must prove, with evidence, that you did not abandon residency. Proof your family remained, proof your home remained, proof your U.S. financial ties remained, proof the assignment was temporary, proof you maintained intent to return. If you are organized, it's annoying. If you're not organized, it becomes months of uncertainty that you did not budget for. This is where you need to understand the triggers described in preliminary guidance. Certain conditions automatically escalate a routine verification into deeper review, a single trip outside the United States lasting more than 180 days, cumulative foreign travel exceeding 240 days within any 12-month period, failure to file U.S. tax returns for any year since obtaining permanent residence, address discrepancies between USCIS records and other government databases, extended gaps in employment without documentation, and maintaining substantial assets, property, or business interests in your country of origin that could suggest your primary residence is divided. Notice what's happening. None of these are crimes. They're indicators. They're risk factors. This is how modern compliance works. The government builds a model of what normal looks like and interrogates deviation. Now I'm going to open another loop, because this is where people make a mistake that is unbelievably common and incredibly costly under an active verification regime. They treat address updates as optional. They update their bank. They update their employer. They update the DMV. They forget USCIS. Under the old system, you might get away with that for years. Under cross-database verification, mismatched addresses can trigger review fast, and worse, you can miss the notice itself. Later in this video, I'm going to tell you how missing a notice becomes a legal vulnerability even if you are fully compliant in reality. Before we move on, I need you to hear this clearly. Being flagged does not mean you lose your green card. But being flagged means you enter a process where your life must be proven in documents, not in truth. That is the psychological shift this law imposes. It removes ambiguity. It reduces benefit of the doubt. It puts the burden on you to maintain an audit-ready life. Now let's talk about the date again, January 30th, because this is where people misunderstand what implementation means. The full digital platform may not be fully operational until later in the year. That is plausible. Government IT rolls out in stages, but the obligation to maintain documentation and the government's expectation that you can respond quickly begins on January 30th. That's the runway, not a grace period, a runway. From that date forward, I didn't know stops functioning as a shield. The system assumes awareness. Responsibility shifts onto you. That's how compliance regimes are structured. They announce the rule, give a short preparation window, and then treat non-compliance as negligence. So what do you do if you hold a green card and you don't want to be ambushed by a verification notice? You build what I call a personal immigration file, one place, digital and backed up, where your proof of continued residence lives. Your U.S. tax returns for every year since you became a permanent resident. A travel log with departure and return dates and reasons. Proof of U.S. residence like leases, mortgage statements, utility bills, employment records, pay stubs, or documentation of how you supported yourself during gaps. school records for children, insurance policies, bank statements showing U.S. activity. This isn't paranoia. This is how you survive in a system that audits alignment. Now we move to H1B holders, and if you're on H1B, I need you to listen like your paycheck depends on it. Because under the law as described, it literally can. The old H1B system had employer obligations, but enforcement was inconsistent. Many companies treated compliance like an annual paperwork nuisance. Jobs evolve, titles shift, salaries change, people work hybrid, teams relocate, and unless there was a site visit, a complaint, or a filing event like an extension or transfer, discrepancies could remain invisible. This law ends that invisibility. It creates a centralized compliance registry and quarterly verification reports for employers sponsoring H1B workers. Quarterly. Every 3 months, your employer must confirm you are still working in the petitioned position, at the approved location, at or above the required wage. If you don't understand why this is explosive, here it is. H1B status isn't just about you. It's about the employer's compliance posture, and the law introduces a status contingency provision, allowing temporary suspension of work authorization if an employer is found out of compliance while issues are resolved. No deportation necessarily, no dramatic cancellation. But your ability to work, your legal oxygen, can be paused because your employer filed the wrong report, missed a deadline, or allowed your duties to drift from the petition without filing an amendment. That is asymmetric risk. The corporation has lawyers. You have rent. The corporation can investigate internally. You could lose income while the system decides whether you're allowed to keep doing the job you already have. Now here comes the devastating mistake for H1B holders. You assume HR has this handled. You assume your company's immigration counsel is tracking it. You assume that because you're paid well and you're in demand, the system will be reasonable. But verification systems don't reward talent. They reward paperwork. So what should you do right now? You communicate and you audit your own file. Ask HR directly whether they are aware of the quarterly reporting requirement and what internal process exists to track job location, salary, and duties against the approved petition. If the response is confusion or dismissal, that's not comforting. That's a risk indicator. Then review your own documents, your H1B approval notice, your labor condition application, your petition details. Compare what's on paper, title, duties, worksite, wage, to what you do today. If there are material differences, your employer may need to file an amended petition. Doing that proactively is a protective move. Waiting until you are flagged turns a fixable mismatch into a compliance incident. And I'm going to open a loop here, because this is where people get hurt in a way that feels unfair. Even if you did everything right, a mismatch can trigger a pause. Later, I'll explain how you reduce that vulnerability by creating redundancy, alternative pathways, earlier green card filing if eligible, and contingency planning, because the new system punishes single points of failure. Now let's talk about DACA, and I'm going to be precise because this is where fear spreads fastest and facts get buried. The law, as described, does not eliminate DACA. It does not automatically revoke protections. It does not create a new removal pathway for otherwise eligible recipients. The program remains. But the renewal process becomes stricter, heavier, and less forgiving. The renewal now requires enhanced status verification, updated evidence of continuous residence, updated proof of education or employment, updated background checks, and biometric resubmission every renewal cycle. That alone can increase processing times, especially during transition periods. But the most dangerous change is not paperwork volume, it's timing. The renewal window shrinks from 150 days to 120 days before expiration. 30 days doesn't sound like much until you remember what DACA recipients already live with: processing uncertainty, staffing shortages, backlogs, and the real-world difficulty of assembling documents while working, studying, and surviving. The law also states, as described, that if your DACA expires even by a single day, you cannot simply renew under the existing framework, and initial applications are not currently available. That means there is no safety net. There is no, "I'll fix it next month." There is no forgiveness for a missed calendar. This is where January 30th matters again. That's when the new renewal window takes effect. If your DACA expires at any point in 2025, you need to calculate your 120-day deadline now and treat it like a hard barrier, not a suggestion. The safest strategy becomes early action. Gather documentation ahead, submit as early as legally permitted, and build time margin for delays. Now step back and look at what all three groups have in common under this law: the end of passive compliance. The system no longer assumes everything is fine unless something triggers a problem. It expects you to be ready to prove compliance at intervals, and it expects your records to match across agencies. That is the quiet danger, because you can be a compliant immigrant and still be an inconsistent data subject. Now, I promised I would close the loop about notices and how people lose status while doing nothing wrong. Here it is. In an active verification framework, the government doesn't need to prove you're out of status first. It can require you to respond to a verification request. If you miss it, because it went to an old address, because you didn't check a portal, because your email changed, your non-response becomes the issue. The bureaucratic system interprets silence as risk. And once you're in a risk bucket, everything gets harder. Renewals, travel, employer confidence, future filings. This is why the most practical, protective move across every category is boring. Make sure your contact information with USCIS is accurate, and build a habit of checking official accounts and notices. In a digitized system, missed communication is not a minor inconvenience. It's a trigger. Now let me give you the most actionable framework you can adopt before January 30th without spiraling into fear. Think like an auditor, not because you're guilty, because the system is automated. For green card holders, your weakest points are travel, taxes, and address consistency. For H1B holders, your weakest point is employer compliance drift, job changes, location changes, salary changes that don't get amended properly. For DACA, your weak point is timing, calendar math, and processing delays. If you want to protect yourself, you do three things. You correct records that are wrong. You document realities that look suspicious in isolation, like long travel or employment gaps. And you create buffer time so you're never operating at the edge of expiration. And now I'm going to say something that sounds harsh but will save people. This law doesn't punish bad people. It punishes disorganized people. It converts life complexity into compliance risk. If you are a permanent resident who travels for work, you don't stop living. You keep evidence. If you are H1B and your employer shifts you to hybrid or changes your title, you don't assume it's fine. You verify whether an amendment is needed. If you are DACA and you're used to cutting it close, you stop doing that now. You submit early because the law removed your margin for error. One more open loop before we end, because I want you to stay with me as this rolls out. The law itself is only half the story. The other half is implementation guidance, how USCIS and DHS operationalize triggers, what counts as material discrepancy, what timelines they actually enforce, and how appeals or corrections work. That guidance will determine whether this becomes a smooth verification process or a nationwide bureaucratic choke point. So here's the bottom line, stated without drama. A new law described as the Immigration Status Verification and Accountability Act of 2025 is now in effect in the source text you were given. It shifts immigration compliance into an active verification model. The first meaningful obligations begin before January 30th, and after January 30th, the expectation is that you are maintaining proof and readiness as if verification could arrive at any time. If you hold a green card, get your address right, get your tax records in order, document travel, and keep proof of U.S. ties. If you're on H1B, talk to HR, audit your petition versus your real job, and fix discrepancies proactively. If you're on DACA, calculate your 120-day window and treat expiration like a cliff, not a line. And if you take one principle from this video, let it be this. In a system built around data matching, your safety is not just your eligibility. Your safety is alignment between your life and your records. We're going to keep tracking how this is implemented, what official guidance clarifies, and where people are getting caught unexpectedly, right here on Immigration News Desk. If you know someone on a green card, H1B, or DACA, you should send them this, because the biggest risk in the first phase of a new compliance regime is not enforcement. It's ignorance. Stay organized, stay audit ready, and don't wait for the system to ask you questions before you prepare your answers.